All right. Hello, everybody. How's it going? This is Immigration Attorney Moumita. I'm coming to you live to talk to you about immigration and to see the questions that you may have on your mind today. Thank you so much for joining me. My name is Moumita Rahman. I'm an immigration attorney, and I have been practicing immigration law for the past 15 years, and I believe that immigrants make America great already. So if you are joining me for the first time, thank you and welcome to my channel. If you are a current client, thank you so much for trusting us with your case. We are sincerely grateful that you have allowed us the chance to shepherd you through this difficult journey. And if you're just joining, if you're a new person, welcome to my live and welcome to my channel. Just so you know, I am live streaming on 4 different platforms at the same time: TikTok, Instagram, Facebook, and YouTube. So welcome. And also, I always love to know where my followers are from, what country you're from, and what state you're in. So anyway, Andrew, thank you so much. Your current client, thank you so much. So that being said, I want to talk about a very, very important topic because I went to an immigration interview this morning, 7 a.m. actually, with my clients, and I want to talk about what to do if you have an upcoming immigration interview and you are worried about attending, or let's say you are supposed to go to the interview with your spouse, but your spouse does not want to go. What are your options? What will happen to you? And should you be worried? Should you change your strategy? What are your best options if your spouse is not going to show up to the immigration interview? Or the other thing that we are seeing, and the other thing is something that you really, really need to be aware of, is what happens if your spouse starts acting funny, right? What happens if your U.S. citizen spouse starts acting funny, starts getting more demanding, starts giving you more of a hard time in the weeks leading up to your immigration interview, right? What happens if your spouse starts saying, "Oh, I'm too busy that day. I don't want to take off work. Why do you always have to ask so much of me? Why do you always give me such a hard time about your case? I'll show up when I show up." What if they don't want to show up for your attorney's preparation, right? This is something that we do sometimes see in our office, is that when couples do not show up to the preparation together, or they cancel, or they show up late, or they just don't even get back to us, and your spouse doesn't want to comply, right? Maybe you're not showing up to your preparation because your spouse doesn't want to comply. That is a form of sabotage that I want to talk about in just a second. Or what happens if you, on the night before your interview, or maybe the morning of your interview, your spouse disappears or gets really drunk, or just is running late or something like that? What does that mean for your interview? So number one, if you have filed a joint marriage case, your case is going to get an interview. You are going to get called in for an interview on your case. There's no way around this right now. We are not seeing any more cases get waived for the interview. So you're going to be required to show up in person, which means that your spouse has to show up too. So if in the days leading up to your interview, your spouse starts saying, "If you don't give me this money, or if you don't do this, I'm not going to go to the interview," or they start playing funny about giving you documents or getting prepared for the interview, or your spouse just plain has abandoned you and is not going to be there at the interview either, you need to talk to a lawyer ASAP. You need to talk to a lawyer ASAP, because the truth is that if you show up to the interview without your spouse, you are going to get a denial. If you end up having to withdraw your case at the interview because your spouse starts giving all the wrong answers, they start pretending like they don't know everything, and the officer says, "Do you want to withdraw your case? Otherwise, I'll give you a fraud finding," and you withdraw your case, then that is also going to lead to a denial. And these days, a denied I-485 can very well result in you receiving a notice to appear to go to court. And that means that you're going to have to defend yourself against deportation proceedings, okay? So if you have an interview coming up, your spouse is not showing up, or you just know that something is going to happen at the interview, you're not confident that they're going to play fair with you and answer the questions properly, talk to an attorney as far in advance of the interview that you can, okay? Don't just wait until the week before or the days before to talk to an attorney to discuss what your options are. Because if you are encountering that level of difficulty in your relationship with regard to an immigration interview, the chances are that your spouse does not want you to get approved, and they're trying their utmost to try to get your results sabotaged. Now, here's the thing. If you are going through that sort of sabotage, that means that usually your spouse is also probably playing a lot of mind games with you. They're trying to manipulate you somehow, and they're probably also subjecting you to something called extreme cruelty, and maybe even you're suffering battery in your relationship, okay? We're not just talking about regular relationship problems. We're talking about the type of problems where your spouse can be controlling, jealous, manipulative, call you names, put you down, and just really demean and insult you, and sometimes even physically harm you. And those sorts of things may mean that you qualify for something called a VAWA I-360 application to protect you from situations like this. But the key is that you have to act as far in advance as you can, and don't just wait until the interview is around the corner, because the closer it gets to your interview date, the harder it is to get the case filed and reschedule your interview. Now, I do want to let everybody know that in the past, what we would normally recommend is that if you have an interview coming up with your spouse and you are going through this sort of situation, for the most part, in the past, you could ask to reschedule your interview and ask for a USCIS to hold your case in abeyance. But one thing that I do want to point out to you is that these days, the trend that we are seeing in the past several months is that, number one, their USCIS is not always honoring a interview reschedule request because of the fact that for whatever reason they claim they never got it, and then they say that you never show up, so they're going to deny the case anyway. Number two, a lot of times, even if we let the USCIS office know that we plan on filing a VAWA case for you, they may still end up denying the I-485. So there's always a 50% chance that even if you reschedule, even if you ask the USCIS field office to hold your I-485 in abeyance, they may still deny it. However, if you qualify for VAWA, the best offense is a good defense, and get yourself qualified and see if you can file, and at the very least, try to get that application in as soon as you can, okay? And if you want our assistance with your case, give us a call, 212-248-7907, okay? All right, let's go ahead and answer some questions. If you are considered a flight risk, are you still able to get an immigration bond, especially if you have intent on marrying a U.S. citizen from VMC? VMC, interesting question. Now, you would be considered a flight risk if you have very little ties to the United States, if you've not been here for a long time, if you have no community ties, no family, no long-term job. Also, if you one more thing they look at for bond is going to be for risk of threat to the community, right? So if you have any criminal history, that will be a factor used against you too. Now, if you're not yet married to a U.S. citizen, you're tied to the community, and you're considered to be a flight risk even more, right? So if you intend on getting married to a citizen, get that done ASAP, because that's going to help you bolster your argument that you are not a flight risk, okay? Do I need to disclose expired protective order from AB? AB, anytime. If you are an immigrant applying for any sort of immigration benefit, if you have any sort of criminal history, right? Even if it's dismissed, even if it's 30 years old, even if it's sealed and expunged, you need to explain it to USCIS. You need to provide the documentation, because the chances are pretty high that they're going to show up in some sort of search anyway. And what you don't want to happen is to be accused of fraud because you concealed criminal history, or in the chance that, let's say, you forgot to mention it or you concealed it and you got approved anyway. In the future, you can even get your status revoked if they find out that you failed to disclose certain certain criminal history, okay? So if you have any sort of criminal history, it is supremely important that you get your criminal charges analyzed by an immigration attorney. Also, just make sure you disclose it. You wouldn't believe how many times most immigration attorneys get surprised by criminal history that the client may not have disclosed, okay? It's for your best interest. I know that you might think that sometimes, hey, if I don't say this to my attorney, they'll never find out, they'll find this case. Well, yeah, we might find the case, but you're the one who's whose case is going to be on the line, right? So, all right. Jana Lee, hello so much. Okay, with new administration, can USCIS decide that your case is not strong enough and just deny it? From Jana Lee. So thank you so much for your comment, by the way, Jana. I really appreciate that. So, okay, this is a very good question because I know that a lot of you are worried, especially people who've already submitted applications. If you have already submitted an application to USCIS, right now, are they just going to deny it because they think it's not going to be approvable? Well, the good news is, well, let me explain. No, they're not just going to deny your case because number one, they still have standards that they have to uphold. There's still law, there's still actual statutes that they have to abide by, and there's also internal USCIS policies that are still in existence and still being enforced. They have written guidelines of how to adjudicate certain cases. They have guidelines. You can even look it up online. You could just Google USCIS VAWA policy manual. You can Google and look up USCIS T-Visa policy manual. These will actually show you how USCIS defines what is extreme cruelty, what is battery, what is trafficking, what do all these things mean? And if they themselves say that extreme cruelty means any action by an abuser to control a immigrant, then that is how you define extreme cruelty for a VAWA case, okay? They can't really go around it. Now, I do want to say that, yes, it is 100% true that they are giving out more requests for evidence and challenging cases altogether a little bit more than they were just 6 months ago. However, that does not mean it's being outright denied. Yesterday, we just got an approval of something we got an RFE on, and we're still waiting for some more decisions to be issued. We're hoping for approvals, of course, but you may get a request for evidence. It does not mean that your case is over. It simply means you have to fight. You have to fight to prove to them, like, this is your rule. Your rule says this. You must process this application that I'm submitting to you according to what you have said is the rule and the guideline, and also what Congress has laid out as law, okay? 212-248-7907. Midnight is asking, do I need to disclose a parking ticket citation in the I-485 form? Midnight, well, the question on your I-485 is going to be, have you ever been arrested, cited, or detained by any law enforcement official? Arrested, cited, or detained. And in our office, we are very, very conservative with this question. And even if you have traffic tickets, we say yes, because a traffic ticket is a citation, okay? So that's what we do. Maybe not every other immigration lawyer does it, but that's our interpretation of this rule, okay? Latoya is asking, how does the interview go when the child is filing for the parent? Latoya, good question. I haven't done like an adult child filing for a parent in a regular process in a while, but the last few times I did it, I recall it was very, very normal. Normally, the officer wants to really just make sure that the beneficiary, aka the parent, is eligible for a green card. Okay, so for the most part, a case where a child is applying for a parent for a regular I-130, I-485 process, they're going to ask the parent more questions than the child, because the case is not really about the child. As long as you have a valid birth certificate, maybe they might ask some questions about like the parental relationship, just to make sure that this really is the child. But I've never seen more than a few questions. Really, it's more on the parent themselves, okay? 212-248-7907. Anna G, I haven't gotten any info back from FOIA. It's been 4 years. Is there a reason for this? Anna G, 4 years is quite a long time, but I guess I wouldn't be surprised. There's just huge backlogs for that. Gil Ramirez, are you in Houston? I'm not in Houston. I'm based in New York City. However, I work with clients all over the United States. I know it's not easy to find a good immigration lawyer, and I know that people don't always want to hire somebody that they can't meet. And I always feel supremely blessed and grateful to people who decide to hire us, who decide to part with their hard-earned money to hire us from thousands of miles away. I think it really, really moves me a lot how much people trust. And every day we work here at this firm, and I work at this firm. I go to bed every single night with all of your cases on my shoulders. I really wake up thinking about my clients. So even though we're not based in Houston, we work with clients. We have lots of clients in Texas, and we work with clients all over the United States because we work virtually with everyone. Can I apply for a U visa now, or will they put me in jail at court? Really interesting question. So if you want to apply for a U visa, what it sounds like is that you're afraid of applying for a U visa because you're afraid that if you go to the police about your crime, you might get arrested. And I think that's a very valid concern. However, we haven't really seen that yet, but I guess you never know. We have been doing several U visas for people in the past few months, and none of our clients have gotten arrested, okay? From just reporting the crime. I submitted a VAWA in May. Is it normal for the receipt to take this long? It's been taking long. It's been average 3-4 months now to get receipts. And I'm going to answer this question because I think it's just so crazy. Why don't you help citizens who victim of a legal person? For someone, well, I mean, I'm an immigration attorney and I'm helping immigrants. And if you're a US citizen, you have no fear of going to the police to get your rights upheld, okay? So good luck to you. Let's see. KKK, any predictions for EV3 visa bulletin? I don't really predict visa bulletins and it's not my line of work, but I hope it moves fast for you, okay? How long does it take to get the EAD based on I-485 CO9 from Rashi? Hello, Rashi. They're taking longer than it takes to get an interview these days. That's what I'm seeing. I'm seeing that we're getting interviews and cases within 7 to 8 months right now, and we're not getting EADs for those clients because the processing time is actually longer than that now. So I hope that helps, Rashi, and good to see you. Gustavo, ¿dónde están las oficinas? Gustavo, nuestra oficina es en Nueva York, pero trabajamos con todos en todo los Estados Unidos, ¿ok? Porque trabajamos virtual. My friend had her interview today and she could not answer info about her sponsor. Would that strike as a red flag from VJ? VJ, it depends. I mean, it's not good. I think if you have a reasonable explanation about not knowing who the sponsor is, then it might help. But if you don't know who the sponsor is, I think that can definitely raise a red flag. Okay, Gopi, can you outline the adjudication process for the I-751, including the difference IOR, MSC, NBC? Okay, Gopi, no offense, but you can actually Google that. Those are just different service center locations, and I'm not going to go into that. But what is the I-751 process? What is the I-751 process, and how does it work? Well, first of all, you would be filing for an I-751 application if you have a 2-year green card already. And why is that? Because you got your green card through marriage to U.S. citizen. So USCIS literally wants you to jump through one more hoop to prove that your marriage was real. And you must file this application before your card expires, within the 90-day period before your card expires, if you are filing with your spouse. And once it's filed, it can take anywhere from 2 to 4 years to process, which is why they give you a 48-month extension letter when you file your I-751. Now, I want to point out the fact that if you got your green card through marriage, but you're no longer with your spouse, you got divorced, you separated, or you're suffering in your marriage, and they are telling you that they're not going to help you file to remove your conditions, then you may be eligible to file the I-751 by yourself with something called a waiver. And you can waive for a variety of reasons. And these can include the fact that you got divorced. It can include the fact that you suffered during your marriage because your spouse was emotionally abusive. You can make this waiver because you suffered during your marriage because your spouse was physically abusive. Also, you can file this because you might suffer extreme hardship if you return to your country, okay? But at all times, you must show that you entered into the marriage based upon good faith, which means that you got married because you wanted to have a life together and not exclusively just for the green card, okay? Now, what happens if you need to file your I-751? Your card is about to expire, or maybe it's already expired, but you're not with your spouse anymore, and also You have no evidence. You have no evidence because they never put you on the bank account. They never put you on any documents. They never put you on the lease. They didn't want to file taxes together. And they just, or maybe they took everything with them, right? What is your option at that point? Well, if your spouse is doing all those things, then you're most likely in a emotionally abusive relationship, which means that you may be eligible to file the I-751 waiver based upon extreme cruelty and battery. And the majority of the time, we help explain to the USCIS officer that our client has no documentation of the good faith requirement because of the fact of how controlling the spouse was or because of the abuse, okay? And we have gotten many cases approved with no evidence. Guys, I'm thinking back to one of my most memorable cases that I got approved just about 7 months ago for a client who was in deportation proceedings, who'd gotten their I-751 denied, and for whom we were able to close out their removal proceedings. And we filed their I-751. Long story short, they actually denied the I-751 again, but we appealed and we refiled. We appealed and we won on appeal, okay? We literally had nothing but a psych eval and like 3 pictures on this case, and we got that case approved, okay? Literally nothing but a psychological evaluation and 3 pictures. That's all my client had, and we got it approved. I mean, it got denied, but then it got approved because we won on appeal, okay? So the bottom line is, do not give up hope. Do not give up hope. Hope is extremely important. It's what keeps us alive, but also a lot of attorneys kill hope because they say things are not possible. Well, I just literally told you a story of my client getting denied twice, not just once, right? And he still won, and he has his green card right now. And we filed based upon extreme cruelty and battery. He only had 3 pictures. That's all he had. So don't give up hope, okay? And if you have a complicated I-751 case, you can give us a call, 212-248-7907, okay? All right. Slivia, hello. I want to ask how much time to take decision for getting an EAD card. I filed in February 2024. Slivia, for the T-visa case, right now people are only getting EADs before approval if they get something called a bona fide determination. And the unfortunate news is that USCIS has been very, very erratic on giving the bona fide determination. So not a lot of people are getting it. Some people are, and a lot more people are not. So you may need to wait until your total case is approved, which would take about 2 years. Emmanuel, I just attended my asylum interview and I'm waiting for a decision. Does it affect my T-visa process? Emmanuel, hello, how are you? So if you attended an asylum interview and you're waiting for a decision, the decision itself will not affect your T-visa case. If you get approved, well then technically if you get approved for asylum, then it no longer needs, you don't need to do a T-visa any longer, honestly. However, if you got denied your asylum case, then that means that if it's an affirmative asylum and your affirmative asylum gets denied after the interview with an immigration officer, then your case will get sent to court. And if your case gets sent to court, then there's a few things that are going to happen. We can try your asylum claim again in front of the judge, or we can put forth other defenses like cancellation of removal if you qualify. Also, a lot of times your case in court is going to take a very, very long time. And within that time, hopefully your T-visa gets approved so we can go back to the judge and ask them to terminate your case, okay? Emmanuel, nice to see you, all right? Let's see. I'm kind of like a little bit out of focus. I hope that's better. Okay. What if applying for VAWA, but you yourself have a domestic charge? I was defending myself against him. From Hadisa. Hadisa, I'm sorry to hear that. Now you have to be very, very careful. Even if you yourself are suffering domestic violence and then you get charged with a domestic violence charge, you have to be very careful because underneath the new Lake and Riley law, you may end up getting detained. You may end up getting subjected to mandatory detention. But of course, if you're suffering that in your relationship and you end up in detention or in court, you may be eligible to ask for something called VAWA cancellation of removal. It's not the same thing as a VAWA application. It's a VAWA cancellation of removal is called special rule cancellation, and that is in front of a judge. Okay, and it's something that you can definitely you can try to ask for. Oh, and also I think Moumita from Luis, thank you. Work permit was approved through VAWA on July 1st. Card was ordered on the 7th, but I haven't received it yet from Maria. Maria, give it about 30 days if you can, okay? Should I be worried going to my I-485 first initial USCIS interview from Florecita? Florecita, okay, so let me go back. I don't think I actually finished answering the question that I started out with, but if you have been called for an interview at USCIS, should you be worried? And the answer, well, this is what I mentioned yesterday, is that if you have a removal order, you probably need to discuss it with your attorney, because the chances of you being detained because of an old removal order are pretty high at the interview. But if you don't have a removal order and you're going for a general interview, you shouldn't have any reason to fear. I went to one this morning. We've been going to interviews, all month long. We've had like a dozen interviews so far this month, and our clients are okay. We haven't seen people get arrested, but definitely for sure, if you have a removal order or some sort of really serious criminal history, make sure you talk to your attorneys first, okay? Visalet, I wanted to know, can I file a motion to terminate our asylum case if my I-130 got approved? From Visalet. Lawyer saying he can't because of Trump. Okay, so that's a really good question. And I have to fight my clients on this a lot, because we have a lot of clients who may have filed for asylum in the past. Their asylum case is still pending, and maybe we're filing for VAWA or a T visa, and they want to immediately withdraw their asylum claim. And we always advise against withdrawing any asylum claim that you have because of the fact, until you get your green card in hand, until you get your status in hand, because of the fact that anytime you withdraw your asylum application, or your asylum application gets denied, you will automatically be issued a notice to appear in court, and you'll end up in deportation. So just because your I-130 by itself doesn't protect you, you need an I-485 or something else. So if you withdraw your asylum application, you're going to end up in court. Okay, Visalet. So I agree with your lawyer. Why are they closing asylum cases and calling for the fear interview? From Halil, because they're messed up. Someone was married and he filed for his partner, but he divorced her while they had USCS case in process. Will the case still be ongoing or closed? From I am Don Julio. Don Julio, this is a great question, because if you have a case in process with your spouse, a joint case, but your spouse divorces you, or they withdraw your case, okay, well, let's talk about the first scenario. If you're married and your spouse has filed for you and then they file for divorce, what will happen to your joint case? And the answer is that at some point, when USCIS calls you for an interview or calls you, gives you a request for evidence, and they see that your spouse is not there or that you've gotten divorced, they're going to deny your case, because technically, if once you get divorced, you have no more legal basis left to continue this case. So you're going to get denied. However, that's sneaky as heck, right? If you're married and you've filed a case together with your spouse and they divorce you, well, typically what I see in my experience is that these are forms of control over a person. And if that happens to you, then you need to talk to a lawyer ASAP to see if you can convert your case to VAWA instead, okay? You can give us a call, 212-248-7907. Thank you, Luis, so much. Can my work permit be denied for owing child support? From Sandra. Sandra, no, I haven't. I've never heard of a work permit being denied because of that. Gopi, yes. So I don't share that story I don't share a lot of stories as much as I should. I just have to remember to share some things, but it's true, and just don't give up hope, okay? All right. What are the consequences of forgetting to change your address by 20 days when filing N-400? Can they deny the application based on the delay? I believe it's actually 10 days. However, this administration has been threatening some other punishments if you're an immigrant and you're not updating your address online within 10 days. So it may not delay your case or get you case denied, but it can subject you to other penalties. So if you have a case and you move, make sure you update your address, okay? Oh, Vslet, if the I-485 was administratively closed, I don't understand why the I-485 would be administratively closed because of an asylum case. Maybe because you were waiting to see if something would get. Well, if your I-130 is already approved, then you should ask to reopen your I-485. But what we do is we still don't withdraw the asylum until the green card is in hand. Once the green card is in hand, then it's much more safe to withdraw your asylum, okay? I gotta address this. Why are you hyping for VAWA? Some people married just to file for VAWA from Salman. Salman, maybe you probably ask people to get married and promise them a green card, but I hype VAWA because I'm not hyping it. I'm explaining a right that many people do not know exists. And my clients are deserving of protection. And please go away. Block. Okay, so I have overstayed my visa. How do I start my documentation process from Riskit? Riskit and anybody else who is trying to figure out what they can do if they've overstayed their visa and they're looking for a way to become legal in the United States. Well, number one, it's very, very important to understand that there are basically 3 buckets of immigration law. The first bucket is family, the second bucket is humanitarian, and the third bucket is employment. The first bucket, family, you need to have a family relationship. You need to have a spouse or a child who's 21 who can file for you, or if you're a child, you need to have a parent who can file for you, right? So that's number one. Number 2 is going to be humanitarian. Well, if you have been married to somebody, they're no longer filing for you, or you've suffered some sort of trauma through trafficking or domestic violence or some sort of persecution, then you may qualify for humanitarian case. And the third is going to be for employment, which usually requires for an employer to sponsor you. Now, if you're in a visa overstay, then you no longer have a lawful presence in the United States. And once your visa gets expired, a lot like bucket number 1 for family and bucket number 3 for employment become disqualified for you because you no longer have the ability to change your status inside the US because of your expired status. But bucket number 2, unless of course you're in bucket number 1 and your spouse is a US citizen. If your spouse is a US citizen, or you are the parent of an adult US citizen, or you're the child of a US citizen, then you're considered an immediate relative, and it doesn't matter if your visa is expired. However, the majority of people don't always fit into that because they may be a preference category relative because their spouse only has a green card, or their child is not old enough, or you may not have a lawful entry to the United States, which means that we need to look in bucket number 2 to see if you qualify for any humanitarian case, okay? So if you want to find out what you might qualify for, give us a call, 212-248-7907. Thank you, Jana. Thank you, Luis. Luis, am I coming to Arizona soon? No, not right now. I don't have any interviews there or plans to go anytime soon. But next time I do, I will definitely announce it. Okay. I sent an EAD renewal through pending VAWA. My current EAD category is CO9P. I received receipt notice, but class category is in C31. And its error. Does this normally happen? Ahmed Gaber, are you sure your VAWA did not get approved? If you got issued as C31, that may just mean that your VAWA got approved. Okay, so check on that first. Okay, let's see what else that I have. My husband received a 2212 notice at the consulate. Will he have to file a 601 waiver, even if he lived outside of the U.S. for over 14 years? From Angie. Angie, no, I don't think so, because the 212 is probably because of the permanent bar. So they shouldn't have to. The I-212 should take care of that. Okay, let's discuss that with your attorney, please. Is it safe to file for asylum now? I mean, it's about the same as before, but as far as what's going to happen in the future, I can't really say. Records of a DUI in 2000 are lost. Will I have problems applying for citizenship? From Ron. Ron, they're never truly lost. I want you to go to the court and get them. It's going to come up, get prints done, get multiple types of searches done, do searches by the state and by the city to find those records, an FBI print, because I guarantee they're not lost. USCIS has those records. If they have those records, then you have to show what happened, okay? Thank you for the follow. Let's see. I have two kids and they're citizens, but I have a green card. Is it going to be risky for me to travel to Nigeria? Very interesting. So if you have a green card, generally speaking, green card holders are still okay to travel. They're still safe to travel. However, what we advise people is that if you have any sort of criminal history or anything that's a little too complicating, then avoid any sort of international travel for the time being. So Maureen, I would say that, generally speaking, it's usually okay, but always discuss with your own attorney to make sure that there's not an issue, okay? Or talk to an immigration attorney before you do. But we don't provide consultations for that. If we are flying domestically and my wife has a green card, should she be okay? Should we renew her Mexican passport so she has two forms of real ID? They seem to be messing with everybody. So if your wife has a green card, that's all. If your wife has a green card, I have to look up to see if a green card constitutes real ID, and I'm pretty sure it does because it's a federally issued ID, but it's need to look up. And if they don't, you should probably just get an actual real ID instead of renewing the Mexican passport, okay? That is what I would recommend. And let's see. Green card holder up for renewal, pros and cons to renew or apply for citizenship after minor theft. 32 years ago. 32 years ago is a long time, and you have to look at your total overall record. But the truth is if you don't want to risk something right now, then leave it alone for right now. If you've been a green card holder for 10 years already and you still haven't applied, maybe you may want to just wait a little bit longer, but talk to an attorney. And if an attorney doesn't think it's a risk and they explain the pros and cons to you and you decide to go forward, for me, I would say a minor theft 32 years ago, it 100% depends on what the record says, on what the actual charging documents were, and what the final disposition and outcome says. We have to inspect that, and it may not be a problem. But that is why it's so important for you to work with an immigration attorney when you are doing any application for immigration. Just try not to go it alone right now. And if you can't afford legal fees, there are some organizations out there. And you can also do research, I suppose, too. But it's always best policy to work with an attorney. Okay, 212-248-7907. Okay. And one last question. What if you're applying for VAWA and you have a misrepresentation from previous paperwork filed? From Pretty Girl. With Pretty Girl, the great news is that if you're filing for VAWA and you have previously committed misrepresentation or fraud to the U.S. government for the purpose of obtaining a immigration benefit, then you can ask for a waiver, an I-601 waiver, by showing that you yourself would suffer extreme hardship, okay? So it is a lot more simpler to ask for it. Now, if the fraud was marriage fraud, that's a different story, and this is not gonna fix it, okay? But if you are in an abusive marriage, you're suffering in your relationship, and you don't have a green card, your spouse is a U.S. citizen or a green card holder, and you maybe you lied on your visa application before, right? This is something very common. There's always a lot of people who say that they're married on a visa application when they're not. You can file your VAWA application with an I-601 and ask for forgiveness of that fraud, okay? 212-248-7907. Okay, guys, thank you so much. I hope this was useful. Please do me a favor. Please share my videos. Please share my lives if you found this useful. And you never know when the information is going to help somebody. And as always, thank you so much for the following. Thank you for being my client if you are a client. And in general, just remember that immigrants make America great already. And I am really, really proud of all of you for hanging in there despite these tough times. Okay, take care, good night, and God bless.